In this lecture, we focus on Article 3 of the Constitution, which deals with the judicial branch. It is half the length of Article 2, which in turn is half the length of Article 1. Once again, Congress was given the power to create the bulk of another branch of government. Because of its brevity, most of what we study today is that which was created by Congress or which evolved over time and use. Article 3 is divided into 3 sections. The first section states that Congress will create a Supreme Court, the highest court in the land. Under the Supreme Court of the United States would be a judiciary system that Congress, through legislation, would create. This was outlined in Article 1, Section 8. Finally, Article 3 states that appointed judges shall hold their office during good behaviour and receive for their services a compensation. SCOTUS stands for Supreme Court of the United States. Section 2 of Article 3 explains the federal court system's jurisdiction, or the area over which it has legal authority. It covers federal law and treaties, ambassadors, states and citizens of different states, foreign countries, federal crimes, and maritime and naval cases. Any cases involving foreign citizens or citizens from different states must be brought in federal court. Today, a lot of the time, the federal courts will kick cases back to the state courts because of the workload they have. The last area that federal courts will deal with is treason or crimes against your country. So Article 1, Section 8, enumerated power states that Congress is to constitute tribunals inferior to the Supreme Court. This would correct the mistake of the Articles of Confederation for federal law, where federal law was interpreted in different ways by different states, courts, or be ignored completely. Just as there is a dual system of laws in federalism, so too there is a dual system of courts. This picture here shows that dual system. In Foley Square, downtown Manhattan, we see the state court on the left and the federal court on the right, named after Thurgood Marshall, who served on SCOTUS for 24 years. The federal court system is divided into 3 levels: district courts, appeals courts, and Supreme Court. District courts were created by Congress in 1789 as per the Constitution. There are 94 district courts with 677 judges. Each state has at least 1 district court. For example, Wyoming, because it serves less people, has 1. California has 4, as does New York. Northern District, Southern District, Eastern District, Western District. New York has 44 district judges, and cases can be heard in the various federal buildings in the city and elsewhere. The second layer of courts are the appeals courts, appellate courts, circuit courts. They were created in 1891 to take the load off the SCOTUS. There are 11 circuit courts for the 50 states and 1 for District of Columbia. As in the principle of one man, one vote, they are located to serve approximately equal number of people. Any cases from the district courts in New York, Connecticut, Vermont are heard in the Second Circuit Court in the Thurgood Marshall Building in Foley Square. Here we see the geographic areas that the circuit courts cover. As I mentioned, they try and create geographic areas with equal number of people on the principle of one man, one vote. The Supreme Court is the only court actually created in the Constitution. In Article 3 it states, the judicial power of the United States shall be vested in one Supreme Court. There are 9 justices, an odd number, to avoid ties. If a justice gets sick, hearings are rescheduled or teleconferenced. There has to be at least 6 present to conduct business, That number is called a quorum. Cases that go directly to the Supreme Court as per the Constitution are those that deal with ambassadors, public officers and consuls. Today, most opinions that are handed down by the Supreme Court concern the constitutionality of laws, or judicial review. The court meets on the first Monday in October and works through June, July with time off for holidays. Judges hold their position for life to avoid being influenced by the threat of dismissal. This harkens back to the independent judiciary established during colonial times. They shall hold their position through good behaviour, it states in the Constitution, and as federal officials can be removed only through impeachment by Congress. To hear a case, the Supreme Court applies the rule of 4. That is, 4 of the judges must decide to hear the case. If the court decides not to hear a case, it is sent back down to the lower court and the decision stands. There are 2 ways to bring cases in front of the Supreme Court. A writ of certiorari is sent down by the court after a case has been sent to it to send up the records. The justices see that a constitutional point is at issue. A certificate is where a lower court certifies to the Supreme Court a question or proposition of law. The certificate contains the facts of the case. Because of the COVID crisis, we'll go back to the 2018-2019 court session for figures. 923 opinions were issued by that court. 644 overturned the previous ruling, and in 261 cases, the ruling was affirmed. Most of the cases came from the 9th district, which is the West Coast and is more liberal. When the court decides to take a case, both sides prepare a file called a brief, a detailed statement of facts which allows the justices to familiarise themselves with the facts of the case. Sometimes amicus curiae briefs are filed too. These are filed by people who are not party to the litigation, but who have an interest in the outcome. For example, with laws concerning anti-smoking regulations, the anti-smoking lobby, the Tobacco Control Legal Consortium, filed amicus curiae with information from the Surgeon General on the dangers of smoking. The lawyers from both sides get to argue their case for 30 minutes in front of the 9 justices, who can interrupt and ask questions. In the weeks after the oral arguments are heard, the justices confer and discuss the case, and they make a decision. Affirm or overturn in a vote of the 9. A majority opinion is written and the reasons given. The most senior judge will write it. A concurrent opinion is one that agrees with the decision, but not the reasons behind it. This precedent was set in Escola versus Coca-Cola Bottling Company in 1944. You can read up on this case if you so wish. Lastly, a dissenting opinion is one that disagrees with the majority opinion, even though the majority opinion is now law. The justice explains why he does not agree and how the case could be different if the facts were different. Dissenting opinions are important to help guide future cases. As I mentioned, the majority opinion become binding law. Here we see the current 9 justices on the Supreme Court. We know from our checks and balances that the executive branch nominates the judge and the legislative branch, the Senate, approves the nomination with a majority vote. The appointment of Brett Kavanaugh, back row on the right, in October 2018 was a major spectacle where hearings were held on his suitability for the bench. In the end, Kavanaugh was approved, but the political partisanship shows the importance of the judicial branch and the power of judicial review. Because the Supreme Court plays an increasing role in determining the constitutionality of laws, or judicial activism as we call it, Getting Conservative or Liberal justices on the bench will reflect the direction the country is going in. From the slide, we see which president nominated which justice to the court. L stands for Liberal and C stands for Conservative. A quick count shows us the Conservative justices outnumber the Liberal justices 5-4. The more senior justices sit and the junior justices stand. That's why the two ladies are standing. The 5 Conservative justices were appointed by Bush Sr. 1, Bush Jr. 2 and Trump 2. With the help of Ruth Bader Ginsburg, front row, second from right, declining, a new position will probably open on the bench within the next 6 months, if not sooner. So either Donald Trump or the Democratic president, if so elected in November, possibly Joseph Biden, will be making a pick. When picking a candidate for the court, the president looks at various factors. Obviously, he will pick someone from his own party, knowing a party member will be more likely to share his views on lawmaking. Judicial philosophy: is he someone who sees the Constitution as the Founding Fathers did, an originalist, or does he/she interpret more liberally, loose interpretation? Judicial philosophy is very important when choosing a judge. Religion: on the court now there are 5 Catholics, 3 Jews, and 1 Protestant. There are no Muslims or Hindus or Buddhists. Perhaps it is time for another religion. Jews only represent 3% of the population, but there are 3 Jewish justices on SCOTUS. Clarence Thomas is the only black judge. Obama had 2 appointees, and I felt he should have appointed another black judge. Today, with the different movements and the general trend of politics changing, judges have to pass the litmus test. Kavanaugh's alleged and subsequently unfounded ill treatment of women reflected the Me Too movement that gripped the country in 2018. He had to defend himself in a pressurized setting and ultimately was approved by the Senate, which voted along party lines. So it's important that a candidate has acceptability. A president can choose whoever he wants, but the Senate has to approve with a majority vote, and the senators are answerable to their constituents, so acceptability is important in a nominee to SCOTUS. Judicial philosophy can be broken into 2 types: judicial activism or judicial restraint. In judicial activism, the court plays an active role in the policies of the country. We see SCOTUS handing down decisions on laws and deciding whether or not they can be implemented. As I mentioned before, the Supreme Court ruled against Trump, allowing Obama's DACA policy to lapse. Laws against gay marriage too have been overturned. Judicial activism comes in 3 types. Firstly, overruling laws as being unconstitutional. Secondly, overruling previous accepted positions taken by courts. And lastly, overruling previous decisions taken by courts. A good illustration of judicial activism is the Brown versus Board of Education ruling in 1954. Brown reversed the stance that the Supreme Court had taken in 1896 in Plessy versus Ferguson. The constitutionality of laws which created segregated educational facilities for blacks and whites was upheld in Plessy on the grounds that segregation in education was okay if equal facilities were provided for both black and white school children. This created the doctrine of separate but equal. In 1954, with the beginnings of the civil rights movement taking off, the court engaged in judicial activism, recognizing that its position on segregation was now wrong, overturned the Plessy versus Ferguson ruling in Brown versus Board of Education on the grounds that separate educational facilities are inherently unequal. Critics of judicial activism feel that the judicial branch is doing the legislative branch's job, making laws, and this upsets checks and balances that the founding fathers had created. Originalists point out that this judicial review is not to be found in the Constitution. Please complete the following questions and put the answers in the correct spot in that answer Google Sheet thing. I will give you a few seconds for each question. If you need more, please do not hesitate to pause the video. Thank you very much for your time and attention so far. This concludes our lecture for today. Thank you for your time and your attention.